See you. Hey, babe.
Hey, Happy New Year.
See you.
Oh, it's cold.
What happened? It went from like tropical to like
I know.
Arctic.
I know. It's miserable.
What do you think about Mr. Chip, man?
Oh, I was happy.
That was weird.
I was happy.
He must have said something to Lori. So, why would he?
Well, you saw his last press conference where he basically denied having responsibility for the personnel decisions.
Yeah,
and I think that frosted Lori's ass.
Right.
You know?
So he's just like, yeah. Well, he said he says I'm not the general manager.
Yeah, bullshit.
It's because that title didn't exist.
Well, right. But you did have control over
that might be
personnel.
what did it. He said, you know what?
Yeah.
That's probably what happened. How many days after that press conference?
2, 3,
Yeah.
max.
'Cause there had to be something that made him not wait.
Yeah. But he was right. The trajectory was the wrong way. We made the playoffs the first year. But then we got rid of Deshaun. So we have nobody to stretch. I loved him. We had nobody to stretch the field. Then we got rid of Shady and Macklin. And again with Macklin, after Macklin had a career year and nobody to stretch the field, you keep Riley Cooper, who's good for what? Everybody we had the dropsies this year.
Yeah. It was. It had to happen. It'll be interesting to see. They might lose both their quarterbacks. They're both 1 year. Imagine that new coach, totally new quarterback. But that may be good because it could be like, all right, a rebuilding year. Jimmy Johnson won one game his first year.
Exactly. I completely expect next year to be a rebuilding year. Hopefully we'll get rid of Billy Davis and we'll go to a 4-3 defense because we've got a good personnel for a 4-3.
Bradford might be a much better quarterback.
What?
Bradford might be a much better quarterback when he's not so rushed. You know what I mean?
I think that's we're going to need some help on the offensive line. Jason Peters, he's great, but he's getting to the end of his other than Jason Kelsey, the other three are about useless.
What can you do without a good line?
Exactly.
You can't pass. You
can't run.
And I think, and they haven't drafted a lineman in 2 or 3 years.
Ages. It's been a long time.
So I think. That's what I think.
The last one they drafted was Lane Johnson.
With a decent quarterback and a great line, you can win.
Absolutely.
You cannot. With a great quarterback, you can't win without a good line. They'll just get killed.
Well, you saw what happened to Tom Brady on Sunday. His offensive line is decimated, and he got smacked around, and he didn't like it one little bit. What a shame.
Yeah.
Welcome to the rest of the NFL, Tom.
Welcome to the Eagles.
Yeah.
Yeah, I think Bradford probably could be a good quarterback.
What?
I think he's a better quarterback than he should.
I think he is. But I don't know.
I don't know if he's a franchise quarterback.
Yeah. And if they franchise him, they're going to have to pay him $23 million next year.
Right.
That's a hell of a lot of money.
Right, and he was paid a lot this year, wasn't he?
Yeah.
Is it 1 year contract?
Yeah. I don't.
Can you imagine that just all the quarterbacks are new? That's kind of cool.
Well, they'll keep Sanchez.
Is he bothering you?
Why?
No, we're talking football.
Oh, okay.
I think he's gone.
Nah.
You don't think so? I think he still wants to start somewhere. And he's
No,
only got 1 year.
he wants to start somewhere else, but nobody's going to start him. He's a pick machine.
Yeah, but he's only a 1 year contract. Do they even want him? He wasn't even that great of a backup.
No, he was a horrible backup.
So why would they keep him?
They went 0-2.
Yeah, they might get rid of him.
Wouldn't break my heart.
Yeah, I wouldn't keep him. He's not even a good backup, so why would you keep him?
I had a lot of questions about the team this year. So.
See, I thought he'd be a good backup.
And did you notice that they ran DeMarco Murray out of the eye a lot more last game? And first run, 54 yards and a touchdown?
Once he gets his steam going.
He needs to get up ahead of steam.
I felt really bad for him.
I did too. They paid him all this money to come in here. And,
well, it's not that. It's just that they didn't utilize him.
Right, well, that's right. They utilized him poorly. Happy New Year, Commissioner.
Good to see you. How are holidays?
Very nice, thank you. Very nice. My tree's still up, so.
It was a bit quiet. That's exactly how.
Well, I put mine up after Thanksgiving.
Oh, thank you.
Thanksgiving, so it's still up and it'll stay up probably until the end of January. So, and all my stuff is still outside, all my Christmas decorations.
Oh, yeah, so ours, yes.
Although I guess it's time to take down the Eagles flag.
Yeah, maybe.
Yeah, probably. So, anyway, we are going to have something to say about the donations. And not really taking a position, but just pointing out that some of the cases that they're going to say also yesterday. And that's what our position is. And I said, based on, I don't want to on side. I haven't talked about it with my father, but I can tell you what I think, which is, I think this is ridiculous. And she said, well, I'm going to have cases. So she said, USI, gas property. They were both. Exactly. Yes.
Those people just
Yes. Exactly. That's my point. So I'm not basically
Yeah, make like we're doing something.
well, you caused this. Don't give me that.
Sorry.
That's yours.
or using a sledgehammer for a thumbtack or bringing a flamethrower to a bonfire.
I did that this night. I can feel good.
Oh, good. I needed something to do. Here in my paycheck.
I don't know, but, yeah, I mean,
You haven't had many FOIA requests lately.
Not lately.
Right
Jeremy's not, isn't he still in China or someplace?
yeah, and it's not like it's,
Yeah, I guess I don't know.
I tried to have him hunted down.
Oh, really?
Yeah.
Well, you can intervene. Get some papers.
It's going to be hard to intervene from prison. No, he's not. I said, but if I had my way, it would be over in Beijing. That'd make your job and mine a lot easier. Did you have a good holiday?
oh, really?
Yeah.
Oh, okay, well, that's interesting.
I'm
Yeah.
bad.
Short weeks are nice. Quiet. I didn't go anywhere.
Well,
By design.
we had kids, children and grandkids. Then we went up to Maine last week, so. Then we went up to settle on the house up there. Yeah. Cool. Now that was cold. Today, flared up there. Yeah, it was colder than.
Get used to it. I mean,
Well, and it's a different kind of cold too, Brenda. I mean, it's there's no humidity at all.
so it's just dry.
Yeah, very, very dry. I mean, a day like today is, you run around and flam through.
Oh, okay.
How long is Dallas gone until April?
Right, I didn't know that.
He's not going to be around much.
Yeah, that's right. So were you saying this one?
That's actually, that's actually,
Hello, Miss
did you have a
Scott.
nice holiday?
Yeah, it was nice. Went by quickly.
I know.
Had a lot of family with us, so that was cool.
And now they're going, so
And
that's
now they're
better.
going, that's even better.
After 3 days, guess
Did you have any about this big screen and yelled?
They weren't, they were a little bigger than that.
Yeah, well.
They make us much of a mess, though, I can tell you that.
I found diapers hidden in places I didn't know you could hide.
That's right, you had
And you
fun.
loved every minute of it.
No, I didn't.
He raised his kids, he's
Once
done.
I'm raised enough. I went upstairs
How
to the
many
TV
times
room.
did you say, okay, I think I'm going to Maine?
No, I'll be upstairs in bed if you need me. I have my little TV room that we've got a sectional in.
Right, right.
So about 8 o'clock every night upstairs.
Got it.
We did go to Maine.
There.
We went up to settle.
Okay, cool.
Guys are there. I just got a call. The guys are there measuring to redo the floors.
Oh my God, he's keeping us like we're getting blow by blows on this house, you know.
I'm happy.
I know you are. I know
That's
you
nice.
are.
That's cool. They got much snow up there or
We
no?
had 10 inches last week, one night.
Ah,
I went to the settlement. We went to the settlement, and then we called the caretaker. He said, "Well, we got it all plowed out for you because we knew you'd want to come out." So.
Yeah, no kidding. Yeah, my idea is I'd rather be in Florida.
Well, I can make believe.
What?
I can make believe.
You can make believe. Yeah, when the snow's all piled up around the trees. Oh yeah, I'm in Florida. Turn the heat up to 80, sitting there in your shirt. Yeah. Oh, it's fertile, all right.
It was just cold.
Well, I just
It
hate
was. You
Florida.
know, the worst part about it is when we got up the next morning to leave, and there was that half an inch of ice
Yeah.
over the.
On the cars and what?
The doors. You couldn't even open the
Yeah, you had to go in and heat a pot of water to.
Yeah. Well, I just left the car running.
Well, how'd you get in?
Waited until it got hot enough that I could.
No Dallas today?
Dallas is not going to be around a lot between now and April.
I see.
He'll be here, I guess, occasionally, but I think they're planning on taking some trips.
Thousands of publications online and what they're posting. I just put in certain keywords and it searches the whole internet and it pulled that article.
Oh, thank
I didn't
you.
send him any cards. I didn't even have a chance. But that was really nice.
Oh.
Did you have a good holiday?
Gina did all this.
It's funny, and it's wound up more now.
Have you recovered from the holidays?
And, but Chip wound up taking like all this shit out. So, unless I was there with him, then I can say, all right, but, so.
The cats and I.
Yeah.
Sullivan and I.
Yeah, exactly.
That's what I've had to do for
But,
Hey, you want some kittens?
No, we still have 6. And in fact, I'm calling a behavioral vet who apparently makes house calls to come down and take a look at Charlie.
No, not in your mailbox. Like
Hopefully, a woman that I work with, I was telling her about Charlie peeing and biting, and she said, we had a cat like that. I used this guy. He came down and, made some suggestions, did, whatever. Apparently, he's a cat whisperer. And she said, we've never had a problem with the cat again. So, please. Because I've been trying everything. I'm trying the feel away, which isn't working. Yeah. So, and he seems to be getting worse, not better. So.
Okay, well, I just didn't. Nothing said that on the thing
What?
that showed up in my mailbox.
Well, yeah. I mean, the woman who talked me into this cat sent me a, Happy New Year. Well, she had said she raised. I probably could have. She did the Humane Association Walk for the Animals, and she raised $29,000. And Tatiana Copeland, who's married to one of
Meeting of January 5th, 2015, comes to order.
The Chair Winslow is on the phone joining us today. He is not in the state of Delaware. And Commissioner Correa is ill, so he will not be at today's meeting. So there are 3 of us, and we have a quorum, so we can conduct business. The first item on the agenda is the reading of the minutes of December the 15th, 2015. Are there any corrections or additions or subtractions of the meeting minutes? There being none, does anybody have a motion?
Madam Chair, I move that the Commission adopt the minutes as submitted.
A second.
Are there any questions on the motion? All those in favor, please signify by saying aye. Any opposed? Any abstentions? There is one item on the consent agenda. Does anybody have any reason why that should be moved, or are there any questions on that item?
No questions.
May I have a motion, please?
Motion to approve consent agenda as presented.
All right, no questions on the motion. All those in favor, please signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions? On to the regular agenda. The first item on the regular agenda is the matter of the request for approval of standard offer service rates, procurement cost adjustment, and RARM filing. Ms. Mayrack, I believe you're our lead off here.
Yes, thank you, Madam Acting Chair and Commissioners. Actually, if there is no opposition, we would prefer to proceed on regular agenda items 1 and 2 together. These are docket numbers 15-0889 and 15-0890.
Does anybody have any objections? Proceed.
Thank you. What you have before you is a motion by staff in each docket and a proposed order asking this commission to impose penalties on Delmarva Power and Light for noncompliance with a commission order. At issue here, in both dockets, the facts are almost identical. There was a filing for approval of rates in April of 2015. On May 5th, the Commission entered opening orders in each of these dockets, directing Delmarva to publish notice of the dockets in 2 newspapers on May 21st and 22nd. On November 24th, over 6 months later, Delmarva came forward to staff and informed staff that they had inadvertently not published the notice. Steps were taken. Delmarva was cooperative in working with staff to remedy the situation, and as you're aware, at the last meeting, the Commission approved orders in both of these dockets, amending the procedural schedule and directing Delmarva to publish notice today and tomorrow to remedy that situation. Staff recognizes that Delmarva came forward with this information, that there was an oversight, that Delmarva worked with us to promptly remedy the situation, but staff still views this noncompliance very seriously and urges the Commission to do so as well. The repercussions of the delay of 6 months of public notice means that any approval by this Commission will be delayed by 6 to 8 weeks. This also means that if there is any refund due to a customer, that refund would also be delayed by 6 to 8 weeks at least. It has taken the time and resources of staff and this Commission to enter an amended order and work with the company to remedy the situation. But what is really most serious is there's an important public policy reason behind publishing notice of our dockets. And yes, steps were taken by the company to notify customers, to enter a press release, to get the appropriate stakeholders involved, but we, for public policy reasons, still publish notice of our dockets so that other players in the industry and the public can monitor the activities of this Commission. And because the notice wasn't published, there was a denial of that opportunity for public participation in both of these dockets. In 15-0889, there was actually additional action taken by the Commission approving documents in the SOS auction process that was undertaken under the understanding, the assumption that notice had been provided and that any parties that wanted to participate were at the table, but unfortunately they were not. Now, we can't go back in time and fix that, but what we can do is take steps to remedy this going forward. And again, the company's worked with us to do that. But that's why the staff takes this issue very seriously. And the Commission is also issuing orders, whether it has to do with the publication of notice or with pipeline safety, where there are significant public safety concerns. And it is important that the Commission's orders are followed and complied with, whatever the subject matter may be. Under state law, the Commission has the authority to impose penalties of up to $1,000 per day for noncompliance with a Commission order. In this situation, I'm informed by staff that this has never happened before. We've never had a utility fail to publish notice for this amount of time. So there is not a lot of precedent, or there's no precedent that we're aware of to guide the Commission in its decision. Although the Commission, by case law, is not necessarily bound by precedent. There's actually a Supreme Court case that states, with respect to this Commission or any agency, that not necessarily bound by prior determinations anyway. Staff would calculate the absolute maximum penalty available to the commission in each docket at over $200,000. So there were a 201-day period of noncompliance, $1,000 per day. Staff is recommending in each docket a penalty of $14,000. And the way that was calculated was from the day that staff was notified of the noncompliance, which was November 24th, to the day that Delmarva came forward with a draft order proposing a remedy. That was a 14-day period, imposing the maximum penalty per day. In each docket would be $14,000. That represents a discount of 93% off the maximum available. So we feel that this is a reasonable and appropriate penalty to suggest, but that it is still significant, representing the seriousness of the noncompliance with the order. And yes, there is a bit of making an example here, because we want, whether it's Delmarva or any utility before this commission, to take the orders seriously and comply with them, whatever the subject matter is. Now, Delmarva, in response, has suggested that a penalty of $0 or of $5 per day would be appropriate, citing back to a docket from the year 2000 that involved dozens of small telecom companies that the commission recognized had been asked to file a special one-time report having to do with their Y2K compliance. And in that case, these were companies that were small, that had limited resources. The commission recognized all of these factors in setting the penalties at the time at $5 per day or $10 per day. In this case, I would argue that that is low. Delmarva is not a small telecom company that has limited contacts with this commission and with this state. They are institutional players here. They are here at every meeting. They should have had procedures in place to comply with the order. And in this case, it seems that the inadvertence or the oversight is less excusable because of that. There have been instances where this commission, in other cases, mostly having to do with unauthorized abandonment of wastewater, where there was significant customer inconvenience, has imposed penalties in order number 6783 of $91,000. In other orders in that same docket, order number 6865, where the maximum penalty per day was imposed to get these wastewater utilities into compliance. So there's precedent for $5 per day. There's precedent for the maximum per day. In this case, what staff is asking for is for the maximum per day for a 14-day period. Just to get, for a comparison, if that $14,000 penalty is spread over the 201-day noncompliance period, it comes out to about $70 per day. So staff views that as an appropriate penalty. Again, given that the utility did come forward, that they did work to remedy it, but still viewing this as a serious instance of noncompliance for an institutional player before this regulatory body. So staff urges adoption of our draft orders in this matter. Those are draft orders 8831 in docket number 150889 and draft order 8839 in docket number 150890.
Okay, thank you. Ms. Scott, do you have anything to tell us?
Yes, thank you, Acting Chair Conaway and Commissioners. Pam Scott here on behalf of Delmarva Power. We certainly agree that it is extremely important to comply with orders issued by this body, and we do that on a regular basis. And in this case, it was simply something that was missed. Both orders were issued on the exact same day at the same meeting, and we missed it. And as soon as we realized what happened, as Ms. Mayrack indicated, we did reach out to the Commission. We did advise them of what occurred, and we worked with them quickly to resolve the issue. And it is correct that you do have the authority to impose penalties up to $1,000 per day for the number of days that a default occurs. Delmarva's position here is that we think under the circumstances a penalty is not appropriate. Again, the error was inadvertent. We worked quickly to resolve it. Despite the error, customers were informed of the rate changes. With the SOS rates, they were informed through a press release as well as bill inserts, and with the RAM costs, they were informed through a bill insert. And in fact, when the rates went into effect on a temporary basis as of June 1st, so they have been receiving the benefit of the reduced rate in the SOS instance, and have been paying the higher rate in connection with the other docket. So we argue that customers have not been harmed because they've already been receiving the benefit of the reduced rates in this instance. In responding to the motion, I did cite to docket 98-492, mainly because that was the one case that I found where the commission actually sort of established some guidelines for how to review when a penalty would be appropriate, and if it was appropriate, in what amount should be considered appropriate. And in that particular case, it may have been small telecom companies involved, but I believe ultimately the commission decided to impose penalties because these companies had been given multiple opportunities to correct the situation and continued to fail to do so. And the commission, I believe, felt that because it was intentional on their part in failing to meet the requirements of the orders with an extended grace period, it was appropriate then to have them pay some penalties. And even in that instance, the amount of the penalties was extremely small, $5 per day, and then an additional penalty of $10 per day for a short period of time. But in that particular case, in doing an analysis of when is it appropriate to impose a penalty and in what amount, there are a number of factors that the commission weighed. And just to recite them, it was the nature, extent, and seriousness of the default or violation, the culpability, intent, or conversely, the good faith of the defaulting entity or violator, the entity's or violator's prior history of noncompliance or violations, the adverse effect of the default or violation on the public interest and regulated industry, the ability of the entity or violator to pay the particular sanctions, and the efforts undertaken by the entity or violator to correct the default. I would submit to you in this instance, again, it was an oversight. We did work very quickly. We advised staff of the situation. We worked very quickly to resolve it. We do not have a prior history of doing this. As I think you heard from Ms. Mayrack, they couldn't find any instance of a utility having done this. We've certainly put measures in place to ensure that this does not happen in the future. And I think viewed in light of those particular factors, I would submit that the circumstances involved here do not rise to the level of imposing a penalty. In the event that the commission believes that the circumstances do warrant a penalty, I would submit that they would be significantly less than what's being proposed by staff. With respect to the other cases that Ms. Mayrack mentioned involving wastewater utilities for which some significant penalties were imposed, again, several that I am aware of involving Bass Properties and some others were intentional failure of these companies to follow the orders of the commission, even after repeated attempts by the commission to get them to come into compliance. That's simply not the situation here, and I would, again, state that I don't think a penalty in this situation is appropriate. Thank you.
Thank you. Ms. Iori, have you anything to add?
I do, Madam Chair. Thank you. Thank you, Madam Acting Chair and Commissioners. I just wanted to maybe give the Commissioners, because the two of you are new and weren't here when Bass Properties and USI were going on, but those are the wastewater cases to which staff referred. Those cases, there were several issues in the USI case. One was the abandonment of the wastewater system without securing commission approval, but there were also issues of whether USI had provided efficient, sufficient, and adequate service and facilities to customers in two developments, the Woods at Herring Creek and Woodlands at Milford, and also USI's transfer of a utility plant consisting of parcels of land without obtaining commission authorization. And the commission did find that penalties were justified under both Section 17 and 308. 308 is not implicated here, but the finding was based on evidence presented before the hearing examiner that the treatment beds had failed and there was effluent surfacing in the infiltration beds of the system serving those two developments, that the USI had been in repeated and long violation of DENREC and Public Health Department regulations, and that surfacing wastewater was a threat to public health. The Commission adopted the hearing examiner's statement that USI's abandonment of its system was unprecedented in the history of PSC regulation, and therefore it adopted the hearing examiner's recommendation to impose a $1,000 a day penalty. However, it gave the violator a grace period and said that if USI was able to get everything under control and remedy all the violations, that it would consider forgiving or the penalty or even rescinding the sanctions. Now, as Commissioner Conaway knows, USI never did take the commission up on that offer, and so the penalties were imposed in full. In the Bass Properties case, that was a similar situation, a failed system and a utility abandoning its obligations with the attendant issues that this raised for the company's customers. And commissioners, even though you were not commissioners at that time, you may have read about this situation in the newspaper. Bass Properties was in the newspaper a lot for this particular development. It was Lay Era Farms in Middletown. So there was these situations that staff cites were egregious situations and deliberate violations of statutes, commission regulations, and commission orders. But there's nothing egregious or deliberate about Delmarva's violation of the commission's orders regarding public notice. Yes, they failed to comply with the commission's orders, but it was a mistake, an inadvertent error, as even staff has recognized. And staff also agrees that as soon as Delmarva discovered its error, it contacted staff and worked with staff to remedy the error. Importantly, for the public advocate's perspective, no customers were harmed by the inadvertent failure to publish the public notice. The rates were decreased. The rate decrease has been in effect since the Commission's initial order. And even if they'd increased, Delmarva would have had to pay interest. As for opportunity for public comment, that opportunity has been provided to customers as a result of the orders that the Commission entered at the last meeting, and should any customers feel the need or want to submit public comments, they have the ability to do so. So the public advocate sort of sees this motion as akin to, as I heard on a commercial over the weekend, using a sledgehammer to hit a thumbtack or bringing a flamethrower to a bonfire. We don't think the Commission needs to impose a penalty on Delmarva in this case to impress upon Delmarva or other utilities the importance of complying with Commission orders. But if the Commission does think a penalty is appropriate in the case to send the message that staff thinks it should send, then the DPA would suggest that it should be more on the side of the 5 or 10 day penalty in the case that Delmarva cited, rather than the full $1,000 a day that Section 217 permits. Thank you.
Commissioners, do you have any questions of any of these people?
Yes, Madam Acting Chair. I have a few questions, please. For Delmarva question, where did you publish notices today, tomorrow?
Today is the News Journal, and those notices are in the paper. I did check. And tomorrow is the Delaware State News.
Okay, thank you. I noted that, as the public advocate points out, that the rates went down. So I'm curious from staff, what's the negative impact on the customer?
Commissioner, that regardless of whether rates go down or go up, I think the real harm here is one in the authority of this commission and its orders being followed, and in the deprivation of the opportunity for public participation. Because there is, as quaint as it may seem in this age with the internet, we still do publish notices in the newspaper. There is a reason for that. There's a public policy reason for that. And we can try to remedy it now, but we can't go back in time and restore that 6-month period where there should have been an opportunity for comment. And it's really that deprivation of opportunity that is the harm. And not just for the customers and for the stakeholders who were involved in the auction process, but for others out there who may have decided to participate had they been given the opportunity of notice, which they didn't have.
Okay. It just seems to me that if the rates had gone up, there perhaps would be more harm than the fact that the rates went down. But that's debatable. Now, a question for Delmarva. What process have you put into place to prevent this from happening again?
We have, through our regulatory division, we have added the publication requirements to our regulatory compliance system that is an internal system that basically sends out notices automatically of when certain reports need to be filed and things along that nature. So we are doing that now, too, with respect to those items that we know have a frequency of at least annually that we file and have to publicize notice for them. So it's added to that calendar. And within the legal department as well, we have added to our tickler system reviewing every agenda the day following the PSC meetings to make sure we've caught anything that needs to be advertised as a result of what happened at the prior meeting.
Okay. Just two more comment and a question. Is there any way on behalf of staff to quantify or estimate the cost of the commission and the staff for the response to this oversight?
I would need to consult with staff to do so.
Is the penalty you are proposing a range estimate of the actual cost, or is that yet undefined?
I would say it's undefined.
Okay. So, and just a comment, I'm not sure I feel comfortable establishing a precedent to fix penalties at the date of discovery, which I think this was based on. And so for that reason, regardless of the quantity of the penalty, I'd worry that going forward, that if we have another case like this, that the clock starts ticking at discovery. And so I'm not sure I like the rationale by which the penalty was built. So, Madam Chair, I have no further comments. Thank you very much.
I have comments. What I'm hearing is that this was discovered by Delmarva. Delmarva came forward. There was cooperation, no precedent, no customers harmed. I would be hard-pressed to find the company under those circumstances.
All right. Do either of you have a motion?
No.
No.
Neither one want to make a motion to either deny or...
Motion to deny
All right, we're going to take each item separately.
each order.
Yes.
Motion to deny proposed order number 8831.
Second.
All those in favor?
Aye.
Aye.
Any opposed? Any abstentions? Motion carries. Docket 150890, which is order number 8732. Do you have a motion on that, please?
Point of order, Madam.
Is it? Yeah. Is it proposed order number 8839?
Yes.
For failure to comply?
Okay,
with
yes, with order. Failure to comply with 8732. Thank you.
Motion to deny proposed order number 8839.
Second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Thank you.
Thank you.
All right, item number 3. Ms. Oliva, I believe you're going to talk to us about that one. The matter of the petition of Vivint Solar, Inc. for a declaratory order, and this was discussed, I believe, at our last meeting. Yes, this was discussed and I believe deliberated and voted on at the last meeting. What you have is an order that memorializes that discussion for your consideration and hopefully adoption today. Okay, thank you. Any questions? Do we have an order? I'm sorry, do we have a motion?
Madam Chair.
I'm reading the wrong thing.
Madam Chair, I move that the Commission adopt order number 8840 as.
I second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Thank you very much. Now we're on to director's comments.
Madam Acting Chair, wish you and the commissioners a happy new year. We'll work towards resolving some of the computer issues that seem to be continuing. Give us an opportunity by 2017 or 2018, we'll have it all taken care of.
Thank you. We'd appreciate that.
Appreciate your patience. The first thing I would like to note that we have an evidentiary hearing scheduled for tomorrow, January the 6th at 10 a.m. It's a hearing that will be held by hearing examiner Campbell Hay, and it will be to hear about a changed methodology for Delmarva's calculation of its gas balancing fees. If anybody feels the urge to attend Delmarva's hearing there, we certainly would welcome them. It's a public hearing. Secondly, on my agenda for notes is Mr. Farber. Mr. Farber would like to discuss with the Commission the status of settlement discussions on FERC docket EL 05121. And so that if in fact you elect to go into executive session, everybody doesn't have to hang around if they don't feel like it. My only other comment was that we will have our next commission meeting on January the 19th here starting at 1 o'clock. So that's the extent of my comments, and I will defer to Mr. Farber to conclude.
Thank you.
Thank you, Mr. Howitt. Madam Acting Chair, Commissioners, good afternoon. As Mr. Howitt mentioned, this is to discuss the status in a FERC docket, EL 05-121, which has had ongoing discussions, settlement conferences. The last one was held December the 16th. And before requesting an executive session in order to obtain guidance on how to proceed with settlement issues, I could provide some background that may help refresh your memory as to what we're dealing with in this docket. Back in the day, the Federal Energy Regulatory Commission, or FERC, would automatically allocate the cost for high voltage transmission facilities, basically 500 kV and above, what was called a load ratio share or postage stamp methodology, which some people have described as the peanut butter approach. It's basically spread to everybody regardless of where the electrons are flowing, and it's based on their contribution to a peak demand. So it's a load ratio share. Everybody participates. The Illinois Commerce Commission, or the ICC, appealed that to FERC, saying that they did not get benefit of those facilities in basically the western states because the electrons showed that those facilities did not provide service, according to them. And therefore they didn't derive benefits, and therefore they shouldn't have to participate in the cost responsibility for those facilities. They went before the Seventh Circuit in Illinois, Chicago, and Judge Posner agreed with the ICC and remanded to the FERC the issue of whether or not the FERC could justify the cost allocation methodology they were proposing, in that there should be commensurate benefits to those who are receiving the costs. On remand, the FERC determined that they could not quantify the benefits, that they were just, supporting a regional market, and therefore they couldn't be quantified. The Illinois Commerce Commission took that back to the Seventh Circuit, and Judge Posner more strenuously remanded it back to the FERC, saying that they must determine a justification for the cost allocation methodology they were using. So at this point then, what we're dealing with in this docket are facilities that had been allocated on 100% load ratio share versus, as you may recall, was called the DFACS, which is an analysis of the flow of electrons on particular facilities, and the way that those electrons are flowing determines who participates in the cost for those facilities. So those facilities were basically created or initiated prior to around 2008. Subsequent to that, there was a settlement that was achieved in a docket so that going forward, there was agreed pursuant to a settlement to a 50-50 cost allocation. So 50% of the cost of facilities going forward were allocated on the load ratio share, and 50% were allocated on DFACS. So we're talking about in this docket a limited group of facilities that had been allocated 100% load ratio share that are now being discussed in settlement as to what level of cost should be continued on a load ratio share or should in turn be allocated on the DFACS. So that's been the subject of the discussions. And we've had as I mentioned, our last settlement conference on December the 16th. And at this point, I would solicit Commission guidance on how to proceed given the results of that settlement discussion. So I would request that we convene an executive session so that we could discuss those issues.
Could I have a motion to go into executive session, please?
Second.
All those in favor, please signify by saying aye. Aye.
Could I just clarify? This is the purpose of this executive session is to discuss to seek, I guess, strategic legal counsel with regard to how to proceed with the FERC settlement. That's the purpose of the request for executive session.
Essentially, that's what it would be. But also, I would be conveying discussions that occurred pursuant to the confidentiality rules at the FERC, which require maintaining confidentiality.
Okay, FOIA just requires that we state a permissible reason for executive session. So if the movement of the motion for executive session would accept my... thank you.
Thank you.
All right. All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? All right. Thank you, everybody.
Happy New Year.
Thank you.
Yeah, put your chair back there. Yeah.
It's like checking the invitation list.